to whoever else is going to give evidence. More fundamentally, are two very important questions. The issues that are before the committee, by the petitioner's own admission, he stated that he had taken them to the ESCC, he had taken them to the DPP, and he had taken them to the court. But he was not satisfied with the way it was dealt with. What does that mean? That the DPP found there was no evidence to incriminate Mr. Ouko. This petitioner was not satisfied, so he goes to court. So we asked the committee that before you hear this issue, can you make a decision whether you are entitled to sit on appeal on a decision by the DPP? If your answer is yes, then fine, you can proceed. But if your answer is no, then you cannot proceed. The committee refused to do that. The law is very clear. If you are dissatisfied with the decision of the DPP, you go to the High Court to review that decision. You cannot appeal the decision of the DPP by going to Parliament. The last point, and this is fundamental, is the question of subjudice. The petitioner states, and is on record, that he took these very matters to court and that there's a case pending in court. Ordinarily, the rule of subjudice applies that if then there's a matter that is actively in court, and on the basis of mutuality of respect, Parliament will not deal with it. Just the way ordinarily, if a matter is pending before Parliament, ordinarily, the court will not deal with it. We raised that matter, but the committee decided that it did not matter that there was a pending court case. There are actually two pending court cases, the specifics of which we gave to the committee, and they are all on the same issues brought to the committee. Interestingly now, when now the matter is in court and the question of subjudice arises, now the committee says the court should not have dealt with the matter that is before us. But the matter was before the courts before it went to Parliament. It's very important to understand that. So if there was a question of mutual respect between the arms of government, Parliament should not have dealt with the matter in the first place. Let me explain three quick things and then we come to the specifics. One, is it true that the court ought not to interfere with anything that Parliament is doing? The answer is yes, but only when Parliament is exercising its legislative mandate, lawmaking. Ordinarily, then the courts will wait until the law is made, and then anybody can challenge its constitutionality. But in this case, Parliament is not making law. Parliament is acting as a quasi-judicial tribunal, and this is very important. When Parliament is acting as a quasi-judicial tribunal, and that is the case, for example, if it comes to impeachment of the president, or removal or impeachment of a governor, or removal of office of the Auditor-General, Parliament or the Parliamentary Committee is not making law. It is acting as a tribunal, an investigative tribunal. When it does that, it is inferior to the High Court, and the High Court can interfere with it at any time, which is why Parliament was able to overrule the Senate on the question of removal of Governor Wambora, which is why the judiciary has been able to interfere even when Parliament made a decision to remove the commissioners of the Judicial Service Commission. You will remember that the courts were able to quash that decision. Anytime they are acting as a quasi-judicial body, then Parliament cannot say we are immune from the courts. The second very fundamental point to make is that the law that guides Parliament on that issue is not the standing orders, but the committee insists it is. It is the Constitution, and it is what we call the Fair Administrative Action Act. Parliament itself last year passed a legislation to this effect, and I invite you to look at it. The Fair Administrative Action Act says that anytime anybody sees as a quasi-judicial body, anybody, then the law to guide it is the Fair Administrative Action Act. Under that act, there are certain things that must be done. This very Parliament passed that law. When then we invite them to follow that law, then they say, no, we will not follow that law. we will follow the standing orders. That law entitles anyone who is aggrieved to go to the High Court. So the National Assembly itself has passed a legislation that says if its committee sitting as a quasi-judicial body does something improper, then you are entitled to go to court, including against that committee. That is the law that they have passed. When then Mr. Ouko invokes that law, then they say you should not have gone to court. But they are the ones who passed the law. So the overall situation here is we are in a situation where Okiya Omtata went to court by himself and has obtained orders stopping the process. Because of the concerns we have summarized, Mr. Ouko also went to court and got orders stopping the process. The orders we have in court stops the committee from continuing with the hearings, stops the committee from receiving evidence, stops the committee from making a report to the National Assembly, stops the National Assembly from debating that report, and if they debate it, it stops them from submitting a recommendation to the President. But if they decide to do that, it stops the President from constituting a tribunal to investigate the matter. What does that mean? It means that if the National Assembly decides to ignore the court order, then it would proceed with the hearings, but everything it does will be null and void. Because at the end of it, the court then will declare that the process had been stopped and every effort, every money, every time will have been wasted. It's a situation which would otherwise be avoided if Parliament respected the court order or respects the court order. The National Assembly itself is represented in court by competent lawyers, and if it thought either that the court do not have that jurisdiction or that order is unfair, then the proper thing is for the National Assembly's lawyers to either appeal those decisions or to apply to set them aside and to make all those arguments in court. If we were to have a situation where we are to proceed despite the court orders, obviously it will result in a very sad situation. So I think we've pointed out to you just 10 of the about 30 reasons that led the Auditor General to go to court to stop the process. It is important to note that the Auditor General that has not gone to court to stop the process so that he does not answer. He has gone to court to ask that, can this process be conducted in a fair manner so that as I respond, it is fair to my rights, to my situation. It is only on that account that he has gone to court. And it is for that reason that we advised him that because of the court orders, he can no longer appear before the committee because that will be in contempt of court. But if the orders are lifted, if they are varied, then he will appear before the committee and still give those very responses. So although he's not appearing before the committee, the Auditor General has still taken the additional step because of accountability to Kenyans to answer anyway, the way he would have answered if the process was fair or if they were to restart a process that is fair. I think that's the situation. Thank you very much.
Thank you very much, lawyer. And from that, I am prepared. And what I'm going to tell you here will also be shared and sent to the National Assembly. Now, what, in my view, irrespective of what has been said by the lawyer, I think we are embarking on a precedence. We must protect the offices. We must see how they are handled or taken out of the office. Now, let me go, and if you allow me, I will read the petitioner's concern and then my response. Now, the first petitioner concern was that failure to submit report to the President and Parliament pursuant to Article 2541 of the Constitution. It is my position that the Auditor General has dutifully submitted audit reports to Parliament in discharge of the mandate which is enshrined in 229. There is no provision specifically that I provide these audit reports to the President. But as for the financial report of my office, which is the audited report of my office, these have been going to Parliament after the audit of my office. And therein are other information apart from financial report of my office. Second, wastage of public funds. The petitioner alleges that contrary to Article 201D, the Auditor-General has wasted public funds by running an iPad charges telephone in excess of 1 million. This is not true. The amount captured in the petitioner and the amounts captured in my telephone bill or in the accounts of my department does not reflect this 1 million. And therefore, I really don't know where the petitioner got the 1 million, and we had asked that he provides us with more details, and we would respond further if he can provide more details of where he found the 1 million. The petitioner alleges wastage of funds, wastage in the use of vehicles allocated to the Auditor-General. I wish to categorically state that I have only 2 vehicles allocated to me and not 5 as alleged. Further, none of my family members is allocated a vehicle. See, the other allegations that the auditors wasted public funds by leasing office space in Mombasa for Kenya shillings 10 million when the premises remained unoccupied or unused in a way by the office for a period of over a year. Generally, issues of leases and acquisition of premises and goods and services fall under the Department of Corporate Services, which is headed by a Deputy Auditor General in charge of corporate services. However, for the citizens of Kenya, I would like to state, as the accounting officer, I am aware that the office entered into a lease agreement with a company called Baywood Holdings Limited for a period of 6 years. While in the process of procuring the partitioning of that office, the Beam House, Mombasa, where part of my staff were housed, offered extra space at no cost. We immediately accepted, and it became necessary to terminate the Baywood Holdings lease at a cost of 10 million. This action therefore saved the taxpayer the 10 million, or in total, if we were to be there 6 years, 43,752,000, which could have been paid for the remainder of the 5 years lease period. The other allegation is that the petitioner alleged that the Auditor General, contrary to Article 201D of the Constitution, initiated a project for partitioning the head office, this is where we are right now, and paid 25 million. Yet no partitioning was ever done, and therefore public funds were used to pay for services not provided. Again, as the other one, this is a domain of the corporate services. However, the intention of commencing, I must explain this, the intention of commencing partitioning project was to convert these offices you see here and these spaces you see here into what you call open space plan, due to a number of staff which were coming on board at that time. The firm contracted to design the project, Celta Crafts Limited, was procured following the normal procurement process, and every procurement process was followed in the procurement of Celta. In the course of the performance of this project, the office received a funding from the Treasury for the purchase of land for construction of what you'd call the OAG offices at Bishop's Road, Upper Hill. In the light of development, the office proceeded to terminate the contract with Celta Craft Limited, who were then paid an amount of 3,463,185,000 Kenya shillings. That design work was not undertaken, and the 25 million, as alleged by the petitioner, was never paid. Further, contrary to Article 201D of the Constitution, the Auditor-General procured Audit Vault software at an inflated cost of Kenya shillings over 100 million. And I personally authorized payment of Kenya shillings 100,675,680. After it's alleged all officers in command chain refused to approve the voucher on grounds of insufficient procurement documentation. As you are well aware, this matter has been the subject of the EACC investigation for over 36 months, basically over 3 years, and which has culminated in a report of the DPP of 3rd February 2017, which exonerated me from any wrongdoing. The EACC, in their appearance before the committee that is considering this petition, alluded to the fact that they were still investigating the matter in furtherance to the DPP recommendations. And I cannot therefore say much on this or purport to answer for those staff who were involved or those who were found culpable. As for the figure which is being branded of 18 million to be the value of this software, and it is not a software, what we are introducing was a system. And this 18 million was to include the software installation, purchase, and so forth, and implementation. This Kenya shilling, which was the cost, the total cost of 100,675,680. And this cost included the software, there were business intelligence tools, and the implementation, including some element of training. Now, why was I concerned or about this Audit Vault and the system? This system was to facilitate my office to be able to, in a real-time manner, see the transactions which are going through IFMIS. And as you know, IFMIS is where the platform which all the accounting for national as well as county accounts are done. And therefore, this would allow me to detect any malpractice within the national and county governments. It has been alleged that I personally authorized payment for the purchase of Vault without formal contracting in place. Yes, an LPO was issued before the contract, but payment was made after contract signing. As would be expected, I signed vouchers of amounts exceeding certain limits, such as the payment of the Audit Vault, but only after other signatories, and this can be verified from the vouchers. The amount about the money trail unveiled by the EACC and reported to have emanated from the payment to a company known as OC Kenya towards the purchase of the software, I wish to state that EACC has confirmed that there was no connection or link whatsoever to me as having benefited in any way from the proceeds of that transaction. However, the petitioner further alleges that of the 100 million paid to OC, that we must mark this, Kenya USD 361,300.25 US dollars was subsequently paid by OC Kenya to a company known as Weston Africa UK, a firm associated with the Auditor General through a Mr. Ochieng Oduol, and further stating that the Auditor General benefited from award of the contract to OC Kenya, and therefore allowed personal interest to conflict his official duties as the Auditor General and Accounting Officer. I categorically state I have not benefited from award of contract to OC Kenya as is alleged. through a separate legal process. I have sought and have asked my lawyers to seek remedies in law against Mr. Mwagona for this malicious and false and reckless utterances, and I wish he had sworn his statement in Parliament. The petitioner further alleges that contrary to Section 74 of the Public Procurement and Assets Disposal Act 2005, the Office of the Auditor-General entered into a contract with Jomo Kenyatta University Enterprises Limited at an approximate cost of 120 million. That the firm was single-sourced by the Auditor-General while in full knowledge that they had no capacity to undertake the review, and the firm subsequently subcontracted to an Indian firm. The petitioner further alleges that the procurement by what we call the JEQUATES, which is the Enterprises Limited, was greatly inflated without following procurement rules. My position is that this was a government-to-government procurement exempt and confirmed from the application of that then procurement law, and the same was undertaken in most transparent manner. A detailed report on IFMIS was produced and presented to the Public Accounts Committee. This audit covered national as well as county. In other words, IFMIS reported national as well as counties. And given the scope of this audit, I consider that the amounts were reasonable and of value. The petitioner alleges that I acted in conflict of interest when the office tasked the auditor appointed by the National Assembly to review the internal audit system of the office, and further that the firm was paid 7.2 million shillings for the said consultancy. I can categorically state that there was no conflict of interest in engaging the firm of Baker Tilly Amerali, who are the auditors appointed by the Parliament, when I asked them to do the internal control system of OAG. This position has been confirmed to the committee by none other than the Professional Institute, which is the ISPAC, and the auditors themselves. I wish to state that this allegation is not true, and I sought approval from the National Assembly via a letter which I sent to the Speaker, and requesting to engage the auditor to review the internal systems of my office. This request was approved and was communicated to me by the clerk. So I did not violate. I asked the approval of the appointee of the auditors, which is the Parliament. The petitioner alleges that the Auditor General has violated Leadership and Integrity Act by employing persons belonging to one ethnic group, more so in Corporate Services Department and in the recruitment of the audit associate, thereby engaging in nepotism, favoritism, contrary to Article 73(2)(b) of Chapter 6 of the Constitution. Recruitment is a function which falls under the Department of Corporate Services, and the Auditor General does not in any way participate in the recruitment process except for the interviews of the highest management cadres. However, in response to this allegation, I wish to state that I am aware the office has observed diversity and incorporates 23 ethnicities in its 1,273 employment workforce. Of this, the highest representation are of Kikuyu extraction, of 481, representing 32% of my staff. Before a year, 2 years or so back, this ethnic community was at 42% of the staff. Now, this is all what I can say of the substantial issues which were raised by Mr. Mwagona. And with that, I thank you, ladies and gentlemen. Well, I can take a few questions, and remember, it should be limited to the point of this press conference. Okay, I think I'll take about 5. Okay, mention your name and.
My name is Moses Jagi of the Thunder.
Yeah, just give me a pen, just a minute. Yes, Moses.
The lawyer has expressed concern about the way and actually you expressed concern about the way Parliament handled the petition, the fast tracking. Do you feel that possibly there could be a push to hold you out of office? And if yes, from which country?
If you're in my position, let's take them all. Okay, let's.
So we take 4 more at random, isn't it?
Yeah.
I don't know what principle we'll use.
The lady was up.
Lady,
yes. Sorry? Brenda. From? KBC.
I actually wanted to ask about
Okay. Okay.
Probably, are you ready to step aside to give the investigation now that you say you want a fair process?
Okay. Who else? Maybe the lady next.
My name is Chemtai.
Chemtai.
I want to find out your move to go to court has sort of been interpreted as you trying to block a parliamentary process. What is your comment on this, and why is it that it appears you're going to the media instead of probably arguing your case elsewhere?
Okay. Yeah. Okay, the 4th one.
My name is Stephen Leto from Citizen.
Citizen.
This afternoon, the Speaker of the National Assembly will give a determination on whether the Finance Committee will proceed hearing the petition. Should the Speaker say give a note for the committee to continue with the hearings? Are you ready to appear before them or hear to their summons going forward?
Okay, let me answer those ones. There's one more.
Which is the 5th, maybe there.
Yes.
My name is Patrick Abimo for KTN. I was just curious with regard to this company that was paid about $36,000 where William Ward is, and it's alleged is your relative. Maybe clarify to us whether you are related to William Ward, whether you know him. And 2, in the recommendation from ESC, it said that you are among the 8 persons who are recommended for prosecution with regard to for having for abuse of office, willful disregard of the procurement laws, among other 4 charges, which later on the DPP disbanded from maybe they will not be sufficiently prosecuted. But why do you think the ESC wanted you prosecuted together with the other 8 plus the OC 8?
Right. Let me, Sam, I might ask you to order. Now, the hounding, let me see if then I can ask you to amplify. So I will answer some, but sometimes also I will ask if he has any additional point to answer, to add to. Do I think I'm being hounded out of the office? I'm also a human being. I'm doing my work, and I see all this happening, like what the process we've gone through, and it's naturally I would feel concerned, and I sometimes then wonder who may be behind this. We wish that the petitioner may have, given the committee the person who sent him to give this petition. Now, the issue of stepping aside, the investigation has been done. The DPP has cleared me. So I don't know, stepping aside, this is the judicial process. It's not an investigation. So I'm not being investigated. So I cannot step aside. The process would be, as it were, constitution. After this process is when there's tribunal which could then be set up. Then after that will be advised by my lawyer. The block block going to the... Why do I hold this press conference? Is it to block the or preempt the proceedings of the Parliament? We want to make sure that things are done properly. This may create a precedence in the future. I have only 2 or 3 years left in this position, but it's not a question of me. It's a question of things being done properly. That's why I'm here telling you. And I'm here to tell you, and as my lawyer said, once the court process is concluded to its logical end and it requires me to go back, I will go back voluntarily and very happily, because I would like the Kenyans to hear my story. And I still feel that in spite of what's happening, the Kenyans have been very supportive and prayerful for me, many. And I think a lot of civil societies have come out, and I owe them a duty to issues so that they know. Of course, it has been explained, if I go before the committee, it would appear to be contempt. Yeah, okay. Deal with allegation. But I do not know Uchengo Duol. I've not met with.
Apologies for that. The signal seems to have been lost there at Anniversary Towers. That is the Auditor-General speaking to the allegations of corruption in his office. He had been accused of a 100 million shilling software contract that was carried out irregularly. He says that he questions the motives with which this is being done, and says that Parliament should not be given the powers to investigate this matter. There's a petition that they are hearing right now that concerns the removal of office for him. He says that this is a judicial matter. He should not be required to step aside because he's not being investigated, and hence why he has moved to court. It is not a ploy to try and block his removal from office. He says he has given all the information necessary to help with the investigations. So that is just what we've heard from the Auditor General. Also, his counsel, Otiende Amolo, who's also the ombudsman, had said that this is a subjudice issue because the Parliament should not be handling a matter that is still in court. We'll be discussing a bit more on this on NTV today. I hear that Otiende Amolo is speaking right now. Let's head back to Anniversary Towers and listen in. My apologies. We'll get the signal back up, which seems to be giving us the issues. Let's take a short break here on NTV today. We'll be right back.